going in a different direction. And I should say that's one of the biggest misconceptions that my clients have, is that an employer needs to give a reason for a dismissal or has to have a reason.
Right.
It's like one of these things that all of us want to know, why did they fire me? Why did they fire me? From a litigation perspective or practitioner's perspective, once it's been acknowledged that it's a without cause dismissal, then the only issue is damages at that point. So it's not that I don't care about the reason, but I have to keep telling my clients that the law doesn't care.
Welcome to Access to Justice. I'm your host, Heather Malarick of Merrick Law. My co-host is Evan Clark of Kahane Law. We're joined today by a very special guest, Kim McDonald of McDonald Advisory. Kim's a financial advisor and insurance advisor with Raymond James Limited. We are a Canadian podcast with a mission to educate Canadians about the law. We interview experts in law, mental health, and finance, focusing on the topics that create the greatest barriers of entry into the justice system. You can find us on YouTube, on our A2J podcast channel, and online at a2jpodcast.com. I am really pleased to welcome today's guest, Mark Alexander Smith. Mark is one of the founding partners of Smith Thompson. He's been a practicing lawyer in Alberta for over 15 years and carries on a diverse and exciting general litigation practice with focus on personal injury, employment law, medical and dental malpractice, construction, and insurance litigation. I had the pleasure of working with Mark early in my career at Weir Bowen, and I'm so excited that he's joining us today to talk about employment law. Hi, Mark.
Hello, Heather, Evan, and Kim. Thanks for having me on board. I just noticed in this lighting, as I reached into my late 40s, I got these transition lenses. So it looks like my lenses are darkening somewhat, but anyways, I'll do my best to see through all this, but this is what happens when you get older, Heather. You start wearing transition lenses and...
Do you know why I'm laughing? It's because I have the same thing, and I think we've had this exact problem before where I feel like they make me look like an 80s serial killer for some reason because I'm wearing sunglasses inside at a meeting, and it's weird. I don't know.
Right. Well, it's good to see you again in the flesh, Heather. Heather and I did work, in full disclosure, at a firm of limited distinction. I think you already mentioned it, Weir Bowen.
Yeah.
I would have been, a 4 or 5 year call at that point. Heather,
yeah,
you articled
right.
Heather, right?
I did, yeah. Yeah.
So that's our connection, certainly. So thanks for having me, everyone. It's exciting.
We're excited to have you. Okay, so employment law, big topic. It's something that I certainly don't know a whole ton about. So I'm really excited to be able to pick your brain about this. So maybe you can let us know, you do employment law, it says on there. What does that mean that you do employment law? Are you helping employers? Are you helping employees? What does employment law cover?
Yeah, principally my practice in the last 5 or 6 years has been dedicated to employees, although I do act for a number of employers as well. Employment law has been a real hot area of practice. And I say that knowing that what that really means is employment law comes into play when there's a bad economy. And so it's kind of a mixed statement because in part we're very busy and that can be lucrative for lawyers. At the same time, it's a consequence of the economy going into the crapper. And then you add to it a global pandemic and it just makes things a lot worse. So when the economy is very good, there is very little bread and butter employment law out there. And the reason for that is that employees, even if they get terminated, they just walk across the street and find a job for the same amount or even more. So we remember the time where oil was over $100 a barrel. And those were times where you wouldn't be that active as an employment lawyer. The caveat would be, of course, if you're doing union work and that sort of thing. So my work, I don't deal with union matters. That's involved with collective bargaining agreements and stuff. My bread and butter is dealing primarily with dismissals and what to do. So on the employee side, I often get calls from referrals and people that call out and say, hey, Mark, I got fired. I don't know why, but they've offered me this amount and a release to sign. Is this a good deal? Is this fair? On the employer side, what I'm seeing more these days is, Mark, we need to get rid of a bunch of employees. We don't know how to do it. We have terrible cash flow. We need some guidance to deal with the number of employees that we need to get rid of. So that's pretty much the bread and butter of what I do. There are aspects of human rights complaints. There's aspects of what's called constructive dismissal. But really, most of my calls come from people that know that I do this work with settlement offers. Is this a fair deal or not? And that really is where I do most of my work.
So is it a fair deal or not, Mark?
Well, what I will say is that because of I'm going to be fair to some of the employers that I'm dealing with. Often a lot of the weird things I see employers doing recently or lately is because of cash flow issues. And so what happens is that where they would normally maybe get legal representation before terminating employees, they're not. And so I'm seeing a lot of just frankly odd and strange reactions to employees that I never saw. You see them once in a while, but it's really a weird and wacky world out there right now where certainly people need legal help. Employers are, I think, stressed as well as employees. They're doing strange things. And so, I've been very active in this area, and I don't see that changing in the next few years because our economy is going to struggle for some time, unfortunately. Unfortunately. Yeah.
What would be an example of one of those unorthodox type of things that has been popping up lately? I'm curious.
Well, for instance, just absurd things like a female employee goes on maternity leave and they get fired while on maternity leave. Okay, just stuff that you would say, how are you not talking to your legal counsel on this? Or someone that an employer that terminates someone on the basis that they've resigned where no such indication has been made by the employee. Or terminating someone for what would be clearly a human rights infringement while they're on disability, for instance. So someone suffers for a work-related accident, they're on WCB, they're on short-term disability, and they get terminated while on short-term disability. Those ones are so obviously clear, even to people who don't know law, to say you can't fire someone when they're on maternity leave, you can't terminate someone when they're on disability. We're seeing all sorts of stuff these days that just are, it's confounding. And the best I can think of, because employers, they're fairly, for the most part, some are quite savvy. In most cases, they don't want to treat their employees poorly. They're just perhaps not getting legal advice before making these decisions. That's the only thing I can really figure is happening, and it's cash flow. It's cash flow. That seems to be the big issue for employers these days.
So I got a follow-up question for a few things that you said there, Mark. So one is, the employer unilaterally decides that the employee has resigned.
Yes.
So what's the context that happens in? Like,
well,
they do something? Yeah, go ahead.
Yeah, I have a case. I won't say the names of it or anything like that, but I have a case where someone who's been working for 30 years for the same company and who's had no disciplinary concerns, has been a model employee, upper management, is getting into their mid-60s and indicated in a sort of discussion with one of the upper management people that he might consider maybe, planning his retirement at some point. That led to an email from the HR department that says, we're happy to accept your resignation. Your last day of work will be August 31st. We'll have a party for you, that sort of thing. Okay, so
that escalated fast.
Escalated very fast. And so, look, long-standing employees are what are a financial risk to employers, for sure. When the auditors do their audits, they say, geez, you got an employee that hasn't taken vacation time in 3 or 4 years. That's all on the books. These are headaches for employers, potentially. And so I guess I'm seeing some things that are what I would describe as strange and unusual in the last few years. And maybe we chalk it up to COVID or cash flow or what have you, but it's, I think, because employers are really struggling out there, and as a consequence, so are employees.
I can't help but wonder, like, how does that conversation go in the boardroom or in the owner's head when, like, because if something like that happens, I think, hey, I wonder if we can just say they're resigning because they're like, I wonder if we can do that.
Right. So just to backtrack, to give you a little bit of the basic law, is that if you terminate someone without cause, you must give notice. Okay. And if you do not give notice, like the old school working notice, then you've breached the employment contract, and the remedy for that is damages, what we call severance, generally speaking. And there are certain factors that a court would consider what a reasonable notice period would be in the circumstance. Your age, your length of service, the type of work you do, the likelihood of you finding new employment. Those are sort of factors, what the court, they're called the Bartle factors. That is what a court considers in determining what a reasonable notice period is. But if an employer terminates someone for cause, so an obvious example, a sexual assault in the workplace on a fellow employee, okay? Immediate cause, okay?
Right.
There's no requirement of an employer in that circumstance giving notice or pay in lieu of notice, full stop, okay? Same if an employee quits or resigns. So employers, what I've seen recently, they want to capitalize on a scenario where it may be unclear as to whether they're quitting or resigning, because if they can, they don't have an obligation to give notice or pay in lieu of notice. So my cynical side is, why would an employer do that? Well, so they don't have to pay them any severance. That's why.
Right.
Best case scenarios, maybe it's just a confusion. Maybe it's a communication error. But you cannot, in Alberta, as with other provinces, discriminate as to age. Mm-hmm. So there's no more forced retirements at the age of 65. There are some exceptions to that, but generally speaking, you're not to be terminated because you're 65. And so, I'm just seeing, Evan, some of the weirdest things in my, I haven't been practicing that long, 15, 16 years, but it is a strange time for employers, employees, and certainly lawyers handling this stuff, for sure.
So another thing you mentioned, oh, sorry, Heather, I saw your mouth open, ready to speak.
Go ahead. I'll keep
She was yawning, Evan.
Another thing you mentioned that I was hoping you'd shed some light on is, you mentioned the term constructive dismissal as something that comes up and people may not be aware of how that's, like employers may not be aware that
Right.
they triggered that.
Right. So constructive dismissal is sort of its own little category in employment law. So it's a circumstance, it would arise in these circumstances. I get a call from a prospective client who's currently employed, so they haven't been terminated. And they say, Mark, I just got a letter that says they're changing my position, they're changing my pay, and they're demoting me to what everyone knows in this department is sort of where they send all the people out to the pasture. What are my remedies? What are my rights? Okay. And so constructive dismissal is a situation where an employer will take unilateral actions to change the terms of the employment contract to such a degree that a court would consider it a dismissal, a constructive dismissal, even though the employer hasn't actually pulled the trigger to dismiss them. So the idea being is you cannot resign or quit a job with a gun to your head, if that makes any sense, or forced to do it. And so constructive dismissal from a practitioner's perspective are often hard claims to make out. I would much rather it be you're being dismissed for no reason whatsoever. Here is what we're offering you. Is it fair or not? A constructive dismissal requires the employer in law, from an evidentiary perspective, to prove that the dismissal was warranted in the circumstances. But from a litigation perspective, you're starting in a hole, if that makes any sense. You're starting in the position that the dismissal was for cause, and you have to get up and over that. And so that can be difficult. So we're seeing a lot of that in the context of mental. I'm being abused in the workplace, and management isn't doing anything about it. I've complained to everyone, all my superiors, and they're not doing. I'm stressed. I've gone on 2 stress leaves, and no one's doing anything. I don't think I can continue this. And so that's a real tough call for a lawyer to make. It's even more difficult for the employee to make. But yes, there are circumstances where you are currently employed, but the court considers it tantamount to a dismissal, hence constructive dismissal. And if a court determines that it's a constructive dismissal, at that point, damages can be sought from your employer. Yeah.
And would those be the same damages that you were referring to before, Mark, that it would be like notice or pay in lieu of notice, or are there heightened awards sometimes for those situations because they're trying to do through the back door what they're not willing to do through the front type of thing?
Right. Well, yes and no. There are a couple. There's a very recent Supreme Court of Canada decision. There isn't a lot of movement in the law. Some lawyers would disagree with me, but it's not like criminal law where every month there's a new decision that you got to pay attention to. In employment law, it's a bit glacial in the changes that are made at the upper end, Supreme Court of Canada. But there is a recent 2020 Supreme Court of Canada decision which reminds everyone that there are actually a number of different causes of action against an employer. So one is whether reasonable notice was given or not. Okay, and that's an assessment of those Bartle factors I talked to you about. So how long you've worked, your age, all those factors. But the court reminds us there are other causes of action. One is a duty of good faith, and one is a duty of honesty or fair dealing. So that in a situation where the constructive dismissal is so over the top, where they just have made this employee's life a living hell, you would be, in theory, entitled to be compensated not just for what the reasonable notice would be. So if you're a 20-year employee or 60 years old, that sort of assessment, but also for other damages which would fall into the duty of good faith or the duty of fair dealing. Okay. In addition, as you know, there would be the potential in very extreme situations for punitive or aggravated damages. But principally, the bread and butter of employment law that most people are dealing with is reasonable notice. Is what they're offering me fair?
Right.
And so I often get asked that question. And so it's one of these things where there's a rule of thumb, but it's not a rule of thumb, but it's a guideline by the courts. But essentially in Alberta, depending on your position, it's somewhere between 2 weeks to 1 month per year of service, which is what a court would determine as reasonable notice. I have to backtrack because we do have legislation in Alberta under the Employment Standards Code that sets out the minimum standard. The minimum standard. And a lot of employers and employees get mixed up with that. The common law works alongside. So an employer can't give less than the legislated amount, but often a court will look at the Bartle factors to say, in this case, this employee should be given 3 weeks per year of service or 4 weeks per year of service, even though the code might say you're only entitled to 8 weeks for any employee over 10 years. That's the minimum. So I often tell my clients, look, you're not going to get much better than a month per year of service. So if you're a 10-year employee, we can shoot for 10 months wages, maybe a year if circumstances are there.
Right.
And there appears to be a cap, although I hate using that word, of 24 months. So it would be an unusual circumstance where a long-standing employee would ever get more than 2 months' wages. Okay.
2 years.
And again, this is in connection with without cause dismissals.
Right.
Okay.
Right.
Where it's just, we're going in a different direction. And I should say that's one of the biggest misconceptions that my clients have, is that an employer needs to give a reason for a dismissal or has to have a reason.
Right.
It's like one of these things that all of us want to know, why did they fire me? Why did they fire me? From a litigation perspective or practitioner's perspective, once it's been acknowledged that it's a without cause dismissal, then the only issue is damages at that point. So it's not that I don't care about the reason, but I have to keep telling my clients that the law doesn't care.
Right.
At that point.
Right.
Now, if it's a dismissal for cause, now it does matter the reason. So one of the misconceptions I have, clients have all the time, they call me, Mark, I've been a good employee for 5 years and I didn't see this coming and I don't know why. And they sent me this letter and I said, well, the good news is they're acknowledging that. It says right clearly on the letter, this is a without cause dismissal. We're offering you 1 month's wages.
Right.
You know, sign the release. So that is probably the biggest misconception that I deal with, is that an employer on a without cause dismissal doesn't need a reason.
Is this different for unions? Does a union have a different way of operating versus non-union?
Yeah, unions are so wacky and weird, Kim, I don't even touch the stuff. And what I mean by that is there are obviously minimum standards, and the Employment Standards Code does apply and the human rights does apply, but it's principally driven by contract, i.e. the collective bargaining agreement, okay? And there are a number of arbitration clauses and meetings and union reps. And so I typically can refer matters out when employees are unionized employees, because it's just not an area I'm comfortable with. And invariably you're pouring through a fairly complex collective bargaining agreement, and there are lawyers out there who know that stuff a lot better than I do. So part of my job is to make sure if I can't handle it, I get my clients into the hands of lawyers who can handle it. Yeah. So I typically do not deal with union matters at all.
That's good advice, because we have so many union people in Edmonton that I imagine people maybe pick up the phone and catch you and you kind of divert them to the union lawyers.
Right. Well, what I tell people who refer clients to me is that if it's a direct referral, I say, look, if I can't handle it, I'll do my best to put them in the right hands. Because that's a service that we put out there. That's how we get referrals. And so there are a number of lawyers that if it's union matters, I usually stop the caller and say, look, it's just not in there, but here's a few people. And I often go the extra distance to let the lawyers know that they're going to receive a call so that it doesn't come off, that they know it's coming. Because, if you have the introduction, then more often than not, the lawyers are going to spend some time with the caller, even if they can't help them ultimately. So,
I have a question about contracts. So you mentioned that, like, sort of in the context of union stuff, but what about the employment contract that a person signs when they get hired? Does that come into play?
Yeah,
employment stuff.
It's a secret that most employment lawyers who do work for employees never want to let out. And knowing that probably no one will be listening to this podcast anyways, I can let the secret out. That's a joke. Okay, the 10 viewers who may see this. When I act for employers, I plead and beg with them to introduce employment contracts. In Alberta, as long as you've voluntarily, and no one's put a gun to your head, if upon obtaining a job, you enter into an employment contract, an employer can lessen his vulnerability to common law damages significantly by having an employee execute an employment contract. It's all fair game. There are some exceptions to that, but typically the earlier a contract is entered into with an employee, the less likely a court would set aside that contract. The only restriction in that contract is that it cannot be, the entitlements can't be below the minimum standards.
Okay.
So I'll give you an example that sort of dovetails, I think, with what we talked about earlier. Let's say you're a 10-year employee. At common law, you might be entitled, depending on your age and so forth, but just for argument's sake, up to a month per year of service, 10 months, okay? Under the legislation, the minimum required is 10 weeks, okay?
Okay.
I should correct that. It's 8 weeks. I'm just going to check because they keep changing this.
Mm.
Yes, an employee of 10 years or more currently in Alberta under the legislation is entitled to an 8-week notice period, which means that that same situation, the difference is potentially 8 months' wages and 8 weeks.
Mm-hmm.
Right? So you can't contract to less than the legislation, but you can contract to the same amount. So from an employer perspective, you are limiting your exposure to long-term employees, payouts for severance down the road by having your ducks in a row at an early stage. Okay. Do you know why employers don't often do employment contracts? Because they don't want to spend the money up front to do it. It's as simple as that. Because if I'm acting for a company that maybe only has 10 or 12 employees, and they say, Mark, what is it going to cost to do up an employment contract? And I said, look, it's going to cost $5,000, but you're going to be saving tens of thousands down the road by doing this.
Yeah.
They say, yeah, I guess we'll deal with that down the road. Talk about crazy things, where employment contracts have been used unfairly more recently is thrusting an employment contract in front of someone who's already been an employee for 10 or 12 or 15 or 20 years, and then terminating them shortly thereafter, signing the contract where you've taken away all their common law rights.
Ah, okay. I can see how
Talk
that
about
might not be.
crazy.
That's
And a
not
court, right, that's not cool. And the court hopefully would say that's not cool, but timing is everything. So I'm seeing a lot more, employers doing a little bit more of that, which can be problematic for employees because now you have a signed express contract that you're fighting to get out from under, and that becomes problematic for the employee. And it's not an insurmountable hurdle, but it just becomes a problem.
And maybe you can't answer this, but if I'm an employee, a 15-year employee of my workplace, and my employer comes to me and says, hey, we'd really like you to sign this employment contract now. We're just restructuring. We met with the lawyer. We're asking everyone to do this.
Yeah.
I mean, first thing I think I'd do is call you, Mark, and have you have a look at it. But what if I decide not to sign it? I mean, what are my choices there then? Am I...
Right.
You could be damaging that relationship with your employer, but you don't want to be shooting yourself in the foot either.
Yeah, I mean, your gut response would be, and you may edit this later, Evan, is to go fuck yourself. I'm not signing this.
Maybe.
That internally, that's probably what most people are thinking. I wouldn't recommend you say that, especially if it's upper management or someone who may view that to be inappropriate behavior in the workplace. But joking aside, that's where you get back to just first principles of contract law. And one of the first principles in contract law is a thing called consideration. So to have someone change the terms of their contract to that degree, let's say it restricts their vacation pay or eliminates their common law rights so that they're only entitled to the legislated minimums for severance,
right,
for pay in lieu of notice, that would demand and require a reasonable consideration. So the better way to approach it perhaps is saying, I'm not opposed to signing this contract, but where's the consideration? So if I'm acting for an employer, I would say you would go to that employer and say, we're going to offer you a $20,000 raise, We're going to offer you an RSP contribution that you haven't been part of, and this and that. But here's the offside of that. We need you to sign this contract. Our auditors have said we got too much exposure to vacation time here and this and that. And then you say, go to a lawyer, look this over. We want you to get independent legal advice before you sign this.
Mhm.
If that were to occur, and I looked at that, I don't think that's something that you can get around, because reasonable consideration has been paid.
Mhm.
They had an opportunity to talk to a lawyer. So very good question, because most of the time employers are doing that, but without the consideration.
Right.
So the key is, if the terms and conditions are all the same, as far as the contract is concerned, fine. If they just want to formalize it, but it's all the same, that's not a problem. If they're changing it, therein lies a problem. So
Right.
how does an employee manage that? Carefully.
Right.
You got to be smart.
Right.
But I certainly wouldn't sign that agreement unless you got reasonable consideration for that.
Mm.
So what I'm hearing from the employer's perspective is there's a right way to do things and there's a wrong way or not so optimal way to do things.
Right.
And apparently sometimes employers are taking the shortcut and not doing things the optimal way.
Yeah, surprising. Have you ever heard of the Pinto, the Ford Pinto? Evan, you're probably too young to know the Ford Pinto.
Oh, I'm not that young, Mark. I do remember
Okay.
the Ford Pinto.
Okay, well, so
Beautiful,
the Ford,
beautiful, luxurious
yeah, the
automobile.
Ford Pinto had a habit on rear end collisions of exploding.
Yeah.
And Ford became aware of this. And rather than recalling, they made a calculated decision that, well, most people won't sue us, so we can afford, but we're selling a lot of these Pintos. So it was a cost benefit sort of analysis, notwithstanding people are dying.
Right.
I wouldn't say it's as severe in the employment world. It's not as exciting, but employers, if you were, and there's no statistics whatsoever to back up this what I'm saying, these numbers, but I suspect that if an employer terminated 10 10-year employees, does that make sense? 10 employees who all had 10 years and offered all of them the minimum under the code, which is not very nice, which is not even a bronze package. I joke with clients when they ask me, is this a platinum package, gold, silver, or bronze? And then there's like the tinfoil.
Right.
So offering a 10-year employee 8 weeks would be a very bad deal. They do so on the basis that most of those employees will just sign whatever is given to them on the spot.
Right.
Okay? 5 of those people might say, I better think about this. 2 of them might go talk to a lawyer, and 1 might litigate. Okay? I'm just using this as an example,
Right.
but
Yeah.
more often than not, on numbers, employers, and again, there are no statistics to back this up, but just my experiences, is that they rely on numbers in part as to how they deal with employees.
Right.
Now, what I say to some of my employer clients is, there's nothing stopping you from being really nice to your employees on a termination. They're like, what? I said, well, there's a minimum standard. It's
Yeah.
kind of like when I go to the bar and get a shot, like you get a bourbon. Well, the minimum standard is an ounce of bourbon. And so I always say to as they're pouring me the shot and it's only half full, I said, there's nothing to stop you guys from pouring a little more. I've paid you, I'm entitled to a minimum of 1 ounce. So, but the point is that there's a minimum standard, but I often say to my clients who are employers, you can give them the platinum package.
Right.
Right? There's nothing stop. And this isn't about being hard on employers. I mean, I've seen some very good packages by employers where the client calls me, I'm on the phone with them for 10 minutes, and I said, there's nothing I can do to help you. That's a really good deal. Do I owe you anything for the call? Nope. That's fine. I'm happy to see it because, I wouldn't say it's rare, but it's a little, I don't see it as frequently in this economy as I used to.
Right.
And so nothing makes me happier than someone calling me and saying, this is what happened. And I say, you can't do better. They're treating you very, very well. I know it sucks that you've been fired, but your employer is treating you very well.
Right.
You were fired the right way.
In the utopian world, hopefully we will have that happen more often. But
Yeah, I sometimes dream about the utopian world where employers treat their employees well and maybe pay a little bit better. But the rest of the world doesn't seem to be catching on.
well, and I see some of the reverse happen too. But again, it's I think to be a good practitioner in employment law, in my view, it's good to work on both sides.
Interesting, because I know some people will choose one or the other.
Yeah, and I know that people who listen to this may disagree with that, but it's same with Heather will know a little bit about this in her pre-family law life. It certainly helped my practice doing personal injury to have worked for insurance companies as well.
Right.
So you can kind of have a better understanding of both sides. And I think that it shouldn't matter what side you're acting for. You should be able to do both. But yes, you're quite right, Evan. Most people will. Most people have chosen to do. I'm either doing employer law or I'm only doing employee law. I do both, and there's others that do too, but there's not a lot of them out there. I would say.
A question about intimidation. I think many people don't reach out to lawyers because they feel little compared to their employer, or they assume that their employer has already hired a lawyer to review the contract. When should somebody reach out to you, or what are the types of people that you want reaching out to you, Mark, to get a second opinion on what they face in paperwork in front of them?
Yeah, it is difficult. I mean, I try to put myself in people's shoes because when should they seek out legal advice? Well, I think my view is whenever they think they need to. That opens up a can of worms for sure, but it's hard to know until you talk to someone whether their concerns are premature or whether they're real and need assistance. Certainly, I would strongly recommend that all individuals who've been terminated and are faced with a package, what they often call a severance package, what is really a payment in lieu of notice package, should consult a lawyer. And in fact, if you ever read, good employers will, and for good reason, will make it clear in that letter or in the release that they've made efforts to ensure that you obtain legal advice. Okay. Frankly, sometimes there's very short fuses on these settlement agreements. So they're like, we really think you should get a lawyer and review this, but you have till tomorrow to sign this piece of paper. It's a bit disingenuous. So that's another complaint that I see out there quite often. But most employers will extend the deadline. They would much rather their employees sign on the dotted line with the advice of a lawyer for the reasons I described before, because otherwise it's unlikely that settlement would ever be set aside in those circumstances by the court. So that would be one circumstance, absolutely, that I would say someone should reach out. The other one is where you have someone that's been involved in a terrible office environment for years and is suffering. And by that, I mean, not that they come home and are just mad about it. They're actually physically or emotionally suffering to the point where perhaps they are seeking out medical assistance. The good news is we're more alive to these issues now, so people are seeking help where they used to just bury it inside. That's what I do. I just bury it all inside, and then at some point it erupts. But other people apparently are seeing people and physicians and treatment providers, which I recommend at an earlier stage. And so I think those people should also reach out to a lawyer to get an idea of what their rights are. I'm not a physician and I'm not a psychiatrist, and so I'm careful in my advice because if their physician or other treatment provider views them to be harmed by working in that environment, then it seems to me that that's not an environment they should continue working in. Now, in practice, the reality is there are a lot of employees who are working in bad environments and continue to do it because they can't afford to leave that job. That's the practical reality. That's the reality. So they'll put up with a lot of crap. But if it gets to the point where you are requiring that sort of assistance, you should talk to a lawyer. Yeah, for sure.
And is that where you're looking at one of those? You referred to it before as a constructive dismissal case. Like if the
Yeah.
work environment is that bad, then you might be able to convince a court that
Yeah, I mean,
that they're pushing you out essentially because it's so bad.
right. Like there's basically two lines of assistance. There's the after being terminated, which is principally the bulk of my work, but there is a fair amount of before termination legal assistance. And often we're in the background because they're still employed. So there is a bit of a tightrope you have to walk on because you don't want to show your, you know, and not in a deceitful way either. It's just that it's a little benefit, I think, if someone's having issues with their employer to say, oh, here's a letter from my lawyer saying you're being mean to me or being unfair to me.
Right.
I would only do that in circumstances where it's at a point where the decision's been made by my client through my consultation and principally through their doctors to say, this is a harmful work environment. We cannot return and we are alleging a constructive dismissal. That's where typically a lawyer might get involved in a more express fashion, an obvious fashion to the employer. But I'm seeing a lot more of that. It's really tricky. There's no doubt we'll see in the next few years that while it wasn't really the work environment, it was COVID. I suspect that will be an excuse that will be used by employers, and it may be valid to some degree. I don't know. I think we all know just that there are people who use the COVID excuse a lot quicker than others. Some genuinely, and some just because it's available. So we'll see how this all plays out in time. Yeah, the before termination type of legal guidance, I'm doing a lot more of that than I ever have. Yeah.
Interesting.
And my classic advice to clients was, don't quit, don't resign, let the employer make the first move. Don't quit, don't resign, let the employer make the first move. I would just, that would be my mantra. But more recently, I put a little caveat, don't quit, don't resign, let the employer make the first move, but unless you continuing to work in this environment is harmful to you.
Right.
Or to others surrounding, or you're in an abusive situation. So,
Right.
so I have had to broaden my my simple instructions or recommendations, but I'm seeing a lot more of that. That's for sure. Yeah.
Are there resources for people? Let's say an adult is getting bullied in the workplace. They are intimidated. They know things aren't going well. Is there something that they should be doing? A website they can go to tracking certain behaviors in the office? Is that a thing?
Yeah, I mean, a lot of the bigger employers have. It's really a tough call, Kim, because what's happened is, and I'm not sure if employers. I want to be fair to employers. I think there are genuine attempts to deal with workplace harassment, abuse in the workplace. And so they have availability and resources. The employer has the availability for employees to talk about that, to seek out treatment if they need it. They often will put signs up in the lunchroom and all that. We're seeing that sort of thing. In practice, God, I don't want to be so cynical, but it almost is a red flag. Like, we got a problem. We got to get rid of this employee. So on the one part, we're asking people to be, look, mental health, let's talk about it. Let's all get it out there. In practice, I think most employers are like, oh my God, this is a headache. This is going to be a problem. Let's get out from under this as quick as possible. And so that's the blunt reality. I don't want to talk unfair. I'm sure there are some great programs that are initiated by certain employers, but in the trenches, what I'm seeing is that those types of employees are viewed to be a risk, and in productivity, in resources, you name it. And so, as far as government programs, yeah, Alberta Health will cover certain therapy and treatment for sure initially. I should probably have a 1-800 number that I would get people to reach out to. But I usually say, look, go talk to the physician that knows you best, and that's often your family doctor.
Right.
And let them make the call.
Right.
Yeah.
I've got a number of questions here. One, Mark, is we've talked about constructive dismissal. Is there such thing as constructive resignation, or is that just dismissal with cause?
Well, well, maybe flesh that out for me, where someone feels that they're resigning because they have no other option but to resign.
Or where the employer is saying, well, you by your actions, you have effectively resigned.
Yeah, you would get that too. It would be a cause dismissal,
Right.
or it's tantamount. It could be folded into constructive dismissal. We've seen weird cases where they say you either do this or you sign this resignation form, right? Or you go work in God, I don't want to be harsh to some town. Let's say Regina,
Siberia. That's safe.
Pile of Bones, Saskatchewan. You go work there or resign. And so those sorts of pressure, coercion, what I call gun to your head, it will not ultimately, hopefully, be permitted by our courts. But that's happening regularly. I hate to say it, but there are people who are given ultimatums all the time at work. So I'm not, interestingly, I'm seeing a lot more people. This is a topic, could be another topic, is they're recording conversations in these meetings, like management meetings, because of Apple, because of iPhones and digital phones. Like,
Yeah, I was going to ask about that. What do you say about that, about people recording stuff at work for any number of these reasons we've talked about?
yeah, the law, as I understand it, a lot of criminal lawyers are pretty up to speed on this law, but the law for these civilly speaking or civil matters is that in Alberta, and this isn't all jurisdictions, but in Alberta, you only need the consent of one party to record a conversation.
Right.
And that one party can be you.
Right.
So there's nothing unlawful as far as I know. And I'm not up to speed on every element of this, but to record a conversation.
I think the challenge comes in whether or not you can use it as evidence.
Exactly. That becomes the bigger issue. And you get into all of those hearsay and exceptions or to what extent it can be even used, even if it's acknowledged that it is genuine in recording. So that is fodder. But having said that, from hit you over the head with a sledgehammer, I've had some very helpful recordings that I didn't initiate or recommend. They just organically happened, which have resolved in fairly quick resolutions. Let's put it that way.
Right, because there's non-legal consequences for saying certain things that get put on some kind of a record, whether or not that record can be used in evidence in a court of law. It can be used in other ways.
It can be convincing.
And I'm sure, God, family lawyers must deal with that all the time with phone calls. They call the ex-spouse and they threaten to do this, threaten to do that. I mean, it doesn't hurt to have it, but the practice I've developed, because I'm not sure whether it's untoward or improper for a lawyer to recommend recording conversations. I don't recommend it, but I will advise of what I understand the law to be, that you only need the consent of one party. You're that one party. So, but I don't say, hey, you go in there and you get a record. Like, that's not my practice.
Right.
Yeah.
And I'm not sure if that would be proper, although I'd have to think about that. Maybe the Law Society would have comment on that.
Yeah.
I don't know. I don't know what your thoughts are on that, but
No, the last time I looked, I think that was the answer I came up with as well, which was that you only needed the consent of one party, but it might go to admissibility or weight if you ultimately wanted to use it at trial. But
now, having said that, I see my own clients now recording. I've caught my own clients recording my conversations.
Yeah.
So what's good for the goose is good. I mean, this stuff, it's all over. So what I say is, if you're on a podcast or you're on a listserv, or if you're assume that what you're saying is going to get out there. Except in your case, because there's only, what, 8 to 10 viewers again that will be watching this.
6. I think we have 6. My mom and dad. And
Yeah. Well, Mark, if you tell people about it, maybe we'll get more listeners.
Okay, all right. I'll do my best. You gotta let me know when it airs. 2030.
Yeah, that's about right.
Reporting thing is really interesting. There's so much in the media about police and body cams, and that many police are wanting the body cams now because it's protecting them. You know, women in the sexual assault issue might be listening to this podcast and think, well, it might not be used in court, but at least people will believe me in the office that so-and-so is a problem. So I think this is fascinating, like a side topic.
Yeah, it is. And again, I'm not going to dispute that it has, like Evan pointed out, legal effect aside. Sometimes it has a practical effect. We're seeing more of that for sure.
Related. Oh, sorry. You go ahead, Evan. Or?
Okay.
Oh.
Okay. This is moving away from that back to some employment things.
Okay.
So I've experienced working in the government, and I imagine working in the government or for the government is probably similar to working for any large corporation. Obviously, there's a little bit of difference, but I'm wondering if you've noticed any trends in with government employees. And as a follow-on question, do federal employees, are they excluded from the provincial employment codes, or do both still apply?
Yeah, so I'll answer your second question first. I don't deal with federal matters either, because they're dealing with federal legislation and federal employment codes. But you're still subject to, an employer is still subject to some provincial statutes, such as human rights and so forth. So that's an area that I don't involve myself in. Again, I recommend for sure. On the government side, what we're seeing is certainly in Alberta, for sure, is just a lack of overall resources. And so as a consequence, when you're looking to limit the load, I guess, often you're looking at from some fairly long-standing employees who are being terminated. Okay. Now, again, bigger operations, government entities, government positions, they often will, if they're not unionized, will have employment contracts in place. So it's fairly cut and dry for the most part. But what I'm seeing, particularly in some of the government bodies that I deal with frequently, wholesale changes in management, bringing in younger employees with less tenure, limiting positions. It's tough. It's a tough time. Yeah, for sure. And I call it the Safeway initiative. In other words, get rid of all the full-time workers and bring in part-times. You don't have to pay benefits. You can pay them less, and they're not unionized.
Right.
I'm seeing a lot of bigger employment kind of functioning that way, with a lot more part-time employees, less long-standing full-time employees. Yeah. And that's a trend I think that will continue. I will say this, that part of the interesting employment side of COVID, and I'm going outside of my my realm somewhat, is part of the reason why there was so much spread early on in a lot of the healthcare centers in Alberta, was because that most of the healthcare workers were part-time workers and working at a number of facilities. Yeah. And so I don't know if you recall when they realized it was airborne and that, hey, how are all these, assisted living homes, what is going on? And what they realized is that because the nursing staffs were principally part-time, they were moving around from facility to facility. And then finally the government followed BC and said, okay, we got to put an end to this. You could only work at one facility. The problem is a lot of these employees relied on having 2 or 3 jobs to make up the difference for not being full-time. So that was an employment strategy that in the context of COVID really failed us. So we'll see if that changes, certainly with nursing and LPNs but time will tell. Time will tell.
Yeah, interesting. I'm going to take a bit of a left turn here. You hear in the news sometimes, and I think they're like the hot topics, but of people getting dismissed for posting stuff on social media. So maybe they've got some bad behavior, whatever you want to define that as, in their weekend time or their holiday time or whatever, and then they're posting that on social media. I mean, I guess I have two questions. Number one, does that happen in real life, or are these just, the one-off, like, outlier news stories? And secondly, can someone be dismissed for things they're doing or opinions they have outside of their employment?
Yeah, well, the simple answer to that is it depends.
Our favorite lawyer answer.
Yeah, it depends. Really helpful. Doesn't really answer the question at all. Kind of. Well, I can give you a real life example. I did have a client who was on maternity leave, and while on maternity leave, she was a genuine maternity leave. She was posting on one of these social media platforms something about she was knitting, about selling stuff on, selling these little scarves and booties she was making while on maternity leave, and the employer took it upon themselves to view that as she was working elsewhere while on maternity leave, and took an opportunity to terminate her at that time, relying on these, social media posts as her somehow breaching her employment contract, which did have an inclusion that she was only work for that firm. But I think for that company, I think the intention was, my view of the reading of the contract was, well, she wasn't to work for any other competitors, but if she wanted to sell booties for $2 or $5. So the answer is, unfortunately, I think that there is a possibility that could come back to haunt someone. In the same way I tell my personal injury clients, the insurance companies are looking at your Facebook page. The defense lawyers are looking at who you are. Mm-hmm. So if you're ziplining in Costa Rica and you 2 weeks before said your back's so bad you can't walk, that's going to be a problem for us, isn't it? There was an interesting article, I don't know where it came from, that whether you could rely on someone's Facebook postings as a true indication of who that individual was. In other words, we have alter ego, Facebook alter egos, kind of.
Oh, fascinating, yeah.
You rarely see a bad picture of a person on Facebook. Hence some of the problems for, I guess, on these dating apps, when you meet them in person, you're like, oh my God, that is nowhere near what your Facebook photo has. Right. But in any event, I caution all of my clients, whether it's employment law, that they will be watching your social media. And certainly there are defamation. I'm aware of defamation lawsuits. Same with listserv, whether it's, Family Laws Listserv or Alberta Trial Lawyers Association or Civil Trial Lawyers Association. There is always the possibility for legal action based on that. Unlikely, but if you're in the throes of litigation, I tell my clients, get off it. Get off it. Now, whether they do so or not is another issue. Yeah.
So I guess what I'm hearing you say, kind of, and correct me if I'm wrong, it's unlikely that employers are snooping up on their employees' Facebooks on a regular basis. But if you've got a problem employee maybe, or something going on, then they might be looking at those things, those kinds of things, to see what's happening. Well,
I think it all depends. If you're in a good employer-employee relationship, I suspect not. I think if they're if they have concerns about you, it's pretty easy to say from the hours of 9 to 4:30 on a work day, you posted 10 Facebook or Twitter during work hours. That could be problematic for an employee, I suspect. Or if you're saying one thing to your employer and then on your Facebook saying another. Now, I do appreciate also that there's a certain level of privacy, and what you do on your own time should be no one else's business. You may recall, as young lawyers, we got dragged into a room early on in our articling it was to talk about how we must conduct ourselves as lawyers, not only as we practice law, but even outside of the practice of law, which I always thought, what are you, nuts? If I want to act like an idiot at the bar, what does the law society, why should they care? Well, they do. And it's bringing the profession into disrepute or what have you.
Right.
I think lawyers are bound with a little more than the average employee on that. But I guess to answer it all depends. But I often tell my clients, watch out on social media for sure.
Right. Right.
Yeah, if you call in with, yeah, I really feel bad. I'm not going to be able to make it in for the next couple of days. And then you go on and you're posting on social media that you're out on the lake.
Yep. Yeah. Or you're down in Vegas hanging out at Spearmint Rhino, which I gather is a place where you play Keno, from what I understand. I've never been there myself.
Yeah, I heard that it's a place for just good, wholesome activities. I've never been.
Yeah, I don't know, but I have no idea. But point being, yeah, you're quite right. You say you're sick and you're not. That's going to be problematic. So.
What about other questions of privacy, Mark? So I'm thinking, I mean, we're still sort of, well, who knows if we're at the tail end or not of this pandemic, but I think we're all hoping we are. But what about questions of privacy around stuff like that? Like, can an employer ask you if you're vaccinated? Can they make rules around, whether you have to wear a mask if that's not in line with the current government regulations? Do you have any answers about that stuff? Because I'm guessing that's coming up for employers and employees a lot.
Right. It's a hot topic right now. And in fact, if you go to any seminar, employment seminar, labor seminar, there's going to be someone talking about COVID.
Yeah.
And how that will impact that. My answer to that is, I think really we don't know how the courts will deal with this until, there's a couple matters that litigated. But one of the big questions that has come up is, can you force an employee to be vaccinated? Okay. So you have existing employees in place. Mm-hmm. And we've all been working from a lot of people have been working from home, but let's assume there's a movement, and a lot of firms, I know, law firms, but also institutions have, big insurance companies, they're looking to have people brought back in September, subject to how these numbers work out recently. Can you institute a requirement that those employees be fully vaccinated? I'll give you my personal view on that, although it hasn't been tested in law. I think there may be a window in that regard, even though it's clearly a breach of your constitutional rights, in that it may be one of those breaches that would be warranted or justified because it's a global pandemic. Now, I know many would disagree with me on that, or the easier, less risky path is never to go down there, never to go that road. You would go about it in more creative ways, where there'd be initiatives perhaps for those who are vaccinated, or perhaps have an extra day off a year if you're doing indirectly what maybe employers are scared to do directly. But my personal view is that this isn't a flu vaccine. The numbers are I don't want to get too much on my views on this, but it is a serious issue. And so is this one of those circumstances where it would be warranted? I'll get, and by warranted, I mean a breach of what otherwise would be a breach of one's fundamental rights, or charter rights. I'll give you an example. More interestingly, is if we were to take in applications for a new employee, let's say an assistant.
Right.
I think it would be improper in normal times to ask them whether they've had the flu vaccine as a condition of work. It'd be an improper question. Right. It would be based on it'd be the same as asking them, can I look at what's your health like, or what, those sorts of questions.
Yeah.
I suspect most employees may wish to volunteer that, but the question is that a proper question in this climate, right?
Right.
Put another way, wouldn't it be nice as a law firm to put on our website, Smith Thompson Law is back open for business. All of our staff and lawyers are fully vaccinated. It'd be kind of nice to be able to say that. So I think that my personal views is that I think there is a window in this case that there would be an exception in the same way we deal with constitutional rights in the normal Section 1 exceptions and those sorts of things. I think, we won't know until some time, but I think with the benefit of what we've gone through, if numbers start to spike again, and it's clear that it's the unvaccinated statistically are the ones who are being impacted by this, I think, it's my opinion, that it may open up a window for employers to be a little more restrictive in who they have as they're asking those types of questions.
Right.
But the best I can say to you is we're not going to know the answer for some time. So I couldn't give any level of certainty if I had an employer who called me and said, "Hey, Mark, can we ask that question?" My answer to that is, I don't know. Perhaps yes. You may not want to be the test case.
Right.
Okay.
Right.
Is the practical side of it really, and so and every lawyer, every law firm, every employer is going to have to deal with this. Now, luckily, organically or not, all of our staff and all of our lawyers are fully vaccinated. Okay, so we don't have this problem.
Right.
But there are many firms, bigger entities that are going to have this problem. So how do you deal with it?
Yeah.
And if it comes down to a real health and safety issue, public health and safety, my family, your family, the thought is, isn't this one of those situations where yes, it's a breach of your right, but isn't it justifiable in the circumstances? I think that's the question that a court will have to answer down the road. And my thought is maybe this is that case.
Yeah. Interesting. Difficult things to weigh as an employer.
Very difficult. I don't envy employers having to make that decision. I mean, if it was over lunch meetings, I suspect people are saying, Jesus, let's get everyone vaccinated so we can end this nonsense. Whether you're fully on board with vaccinations or not, there's some utility in having everyone vaccinated.
Yeah.
From just a customer perspective, whether you're selling widgets or beers or legal services, like we all understand that.
Yeah.
But I guess time will tell.
I'm searching my memory right now. I was out somewhere on the weekend and there was a sign posted outside the business and it said, our employees are 81.8% vaccinated or something like that. I'm trying to remember where that was. I never thought about that from like an employer and employee kind of perspective.
Which epidemiologists or doctors would say, that's terrible. This place is this is a bad. Don't put that up. So what you're saying is 20% of your employees. So I mean, it depends on how you look. Yeah, you look at this as a.
Yeah.
But yes, no, I think people will be using it as a. I hate to say badge of honor because that brings back. I mean, it's just it will be used where it's beneficial to employers. I suspect. Just like the airlines tried to coax everyone to fly during times when they probably shouldn't. That's another topic for another day. But the false sense of security, call it whatever it is. But that would be, I think, a good follow-up episode because I suspect that someone will take a run at this. Sometimes lawsuits are, I won't say created, but they're manufactured so that we get an answer to these questions. Yeah. And I suspect that's an answer that we need. Because I don't think COVID's going away, and this vaccine, we're talking now about third doses and all this other stuff. So it's going to be around for a while.
Yeah. Yeah.
unfortunately. Yeah.
Yeah, and it'll be interesting to see that lawsuit we have with the church or the pastor from that church out in Stony Plain who's bringing the constitutional challenge, saying
Right.
it'll be interesting to see the answer there because.
Yeah, and that there's an example of you have a bunch of cross streams there. You have religious rights, you have rights to be safe and have a safe community and the public. So yeah, it'll be very interesting how that plays out. I mean, I haven't been following more recently what's been happening, but I guess the problem, I think, ultimately is that there were certain, whether you agreed or not, there were certain health requirements and standards that they continued to violate, and that's going to be problematic for them. Even if ultimately they had a point to make and it was a fair point, like,
Right.
should a court be forcing people to vaccinate, or should a court be forcing people to separate when they want to get together and they understand the risks and so forth?
Yeah, I think it comes down to like obviously the government's saying, yeah, this is an infringement for sure, but it's justified,
Right.
right? And then theirs as well, is it justified? Because did you actually know anything, or did you just make this stuff up?
Yeah. Is this all? I mean, I think this falls back. I don't want to trivialize the significance of those issues, but I think there were similar arguments when the seatbelt legislation came in. This is a violent. If I don't want to wear a seatbelt, and it was determined, look, it's for your safety, dummy,
Yeah.
and it's for the safety of others, and so and for our healthcare. So yeah, we are breaching your rights, but we're doing it for a justified reason.
Yeah.
And so, just like we make motorcyclists wear helmets, you know.
Yeah.
Like Heather, I'm sure if Heather rode a motorbike, she would want that beautiful mane of hair flying behind her.
I mean, it would look a lot better.
Unfortunately, she's got to wear a helmet.
Yeah,
That's,
and I would.
That's the law.
Yeah.
Sorry about that, Heather.
Yeah.
Dang
We
it.
can edit all of that out, Heather.
Oh, it's staying in.
No, that's fine. Then people will have to watch the video too to just see how good my hair looks.
Now, do I have any control over the editing? Did I sign something to give up? I don't. Kim is saying no. Oh,
No.
goodness. I'm
He's got a
screwed.
no-go.
I haven't sworn that much. I haven't really made a lot of politically insensitive comments yet. I haven't.
Plus, I feel like it'll give us a little bit of street cred, at least having one episode with the explicit mark next to it.
Yeah.
I think I'm going to leave that F-bomb in there.
Okay, I've got a question. This is
Sure.
I've been sitting here listening to you guys rattle on a little bit, and my mind's going elsewhere. And I'm thinking about group benefits plans that offer free. Many of them offer free legal advice. So somebody's getting turfed. They've got free benefits. Free legal advice to their benefits. Wouldn't they always just maybe reach out to that legal entity and say, I got terminated, here's my package, have a look? Would they have people to look that over? And the reason I'm thinking about this is because I always ask all of our guests what they cost, because I got to build this into budgets in my world. People
Yeah.
want to know what you cost. So do you have any insight into the benefits, free legal advice, and what it costs to hire an employment lawyer?
Right. So I think what you're talking about, Kim, I know of a couple of, it's part of insurance plans or disability where they, am I able to name those? Or do you have any concerns about? Blue Shield, for instance, is one I'm aware of. Okay. And so what the concept is through your insurance plan, whatever it happens to be, you would be entitled not necessarily to free legal advice, but a legal advice at a reduced rate as part of your. So when the insurer or the broker is pitching the benefits of this plan, they would say, oh, and also you'd be entitled to access to these wonderful lawyers that would do work on a reduced rate, which frankly is a good idea. But ultimately, I don't think you're going to get free legal services throughout the course of a lawsuit. That's not my understanding, nor would that. And for full disclosure, I do some work for Blue Shield and do offer legal services at reduced prices because I'm one of the lawyers they reach out to. But I think someone better be careful in looking at what that really means. I would say to anyone who is being wooed or, there's that incentive, should take a look at what that really means. But there are services out there that provide some reductions of legal fees that would otherwise be charged. That's for sure. Yeah.
Yeah, I'm familiar with some insurance companies that offer free legal advice. You get a certain number of hours that you can utilize as part of your group benefits package with your employer. So I was thinking, are they any good? And should you, if you're terminated, you still have access to these benefits for maybe a week, maybe a bit longer. Should you reach out? Is there any harm?
Right. Well, I would love to know that, because it may be an avenue for me to provide, several hours of consultation, and it's paid through the insurance rather than out of someone's pocket, if it's available to them. Kim, I'm not aware. You're more into that sort of side of things, insurance. I'm not aware of those sorts of for employees. Although certain professional bodies have that. They'll have up to $5,000 as part of their professional fees could go to outside or legal representation up to a certain amount of money. So maybe that's a similar thing. They'd have a limit, just like you get so much for physio, you get so much for chiro.
Right.
Well, maybe they got $500. I think that all makes sense to me. I haven't been on the back end of that type of program where someone's called me.
Let's get you on there.
Yeah, so this is great. So we should start up our own little program, because that seems like an excellent plan, Kim. And anytime I can get insurance companies to pay for things, it makes me happy.
So what does an employment lawyer cost? Is it similar to family law lawyers, like in terms of?
Oh no, we're much more reasonable than family lawyers, Kim. And that, well, anyways, that's a discussion we had pre podcast. But principally, I take on matters in two ways. One would be hourly, and so my hourly rate is $450 an hour. I'm a lawyer of 16, 17 years. We view that to be fairly competitive, if not better than a lot of the bigger lawyers in big firms. I have to say there are many good lawyers at big firms. The problem with big firms these days is they often get conflicted out in representing employees, because they represent so many employers, companies. So that is really why most employment law, not all, most employment law on the employee side is handled by smaller firms like ours, because we are not a corporate law. We're not encumbered by those sorts of conflicts. And some of these multinational firms, you can imagine how many employers they act for, or subsidiaries of companies. It creates a very difficult time, I suspect, for a lawyer to carve out a plaintiff's practice in employment law.
Right.
We also take a fair amount of claims on contingency, depending on the circumstances. And so when I spoke of the bread and butter type, where it's a without cause dismissal, the only issue is really what are the damages. We do on occasion take those on contingency in circumstances where, and particularly in employment situations, most of the people calling me, they just got fired. They have no money. And what we realized during COVID is many people don't have a lot of money saved. Sadly, it's just how it is in Alberta. So they literally don't have an extra $1,000 or more to even if they wanted to give you an initial retainer to see what happens. So we often take those claims on contingency, but there is a risk side to the law firm. So what I tell them, I tell my clients straight up that, we do some pro bono work, but at the end of the day, I have a mortgage just like them, and I have a family. And so we got to be pretty careful in what claims we take on contingency. And what contingency means, for those who aren't in the know, is basically we would only take fees once we reached a settlement or obtained a judgment if we went to trial. So there are every firm has different styles of contingency, but in essence, what it is that we don't ask for money up front from the client. We would carry the disbursement, so out-of-pocket expenses that our firm spends. And in the event of a settlement, we would take a percentage. So the example I give to people most often is if at the end of the day we get 10 oranges, you get 7 and we get 3. Okay, pretty simple way to explain it to someone.
Yeah.
And then they say, well, how about 2.5 oranges? And I say, well, how about 3.5 oranges? And then we get back to, okay, 3 sounds good.
And then
Way
they're more
reasonable
convinced.
than the dirty family lawyers.
Yeah, dirty family lawyers, as we found out, don't take matters on contingency. They just, now, one of my complaints about family lawyers, not to throw you guys under the bus, but
We could take it.
as a lawyer who doesn't do family law at all, and who knows a bunch of family lawyers, it is nearly impossible to get a family lawyer, even ones that I know, to just talk to my client or talk to my referred client. And in part, I think it's because we need a lot more family lawyers in Alberta. I think we don't have enough, and we don't have a lot of public funding for family lawyers, as I understand it, like other provinces.
Yeah.
So we don't have the resources. So while most family lawyers had altruistic purposes in university, I want to make a difference. The rule is they're not talking to you until a retainer is paid and secured in that trust account. But joking aside, we need, I don't know, Heather will know this, we need some public money to provide, and I think there's a bit of it, but I don't think legal aid is covering much of the family law.
No.
Are they getting involved in they'll get involved in custody matters, will they?
Yeah, but the income threshold is so low to qualify for legal aid that it's, barely scraping.
Not only that, like, yeah, that's a huge problem. Like hardly anybody that is impoverished can even meet that threshold. You got to be really impoverished.
Yeah.
Yeah.
Not only that, but the government expects the lawyers to actually fit the bill, because the legal aid certificates they pay a fraction of the going market rate.
Yeah. And there's a lot of administrative hoops that need to be jumped through. You get a limited number of hours to run a file, and they cover, this may be dated information, but my most recent information is that there's got to be an active court action going on as well. So you're not getting access to that to help people just settle things. Like, you're already in litigation in court and that whole thing. So you're really narrowing down the categories as you plinko through all of those requirements, right?
Right.
Mm-hmm.
Yeah.
That's another Plinko reference. I think that's 2 weeks in a row, Heather.
Is it? Oh man, what is? I got Plinko on the brain. I don't know what's going
Is
on.
this old Bob Barker Plinko or my brother Drew Carey?
I don't know.
It's Bob Barker. It's Bob.
Not joking aside, I think from my view, and of course I don't do any family law. As they say, I found out early on what I didn't want to do before I found out what I really wanted to do. But family law is just not an area that interested me, and it strikes me from my position that there isn't enough family lawyers out there, maybe, and you guys are super busy, and so it's really hard to when I get calls as a lawyer from my clients or friends of mine to say, hey, Mark, who can you refer me to? That's a struggle to find a family lawyer that can help out. And so I think that needs, you guys there's lots of bad things you can say about personal injury lawyers too, but I think it's something that needs to be sorted out in an institutional sense, because it's help that's needed. But you guys have mortgages too. You guys got families, you got firms to support, so it's a tough one. So
Yeah.
Ken, yes, contingency and hourly are typically how we proceed on employment files. When I was talking about constructive dismissal, most of those, if not all of those cases, not all, but most, will be on hourly basis, because there's no assurance at the end of the day that you will be able to obtain a settlement for your client, unlike dismissals without cause. For the most part, it would be, and the analogy would be, it's the rear end motor vehicle accident of motor vehicle litigation. In other words, you're pretty sure that the employer's on the hook. It's just a question of what's the reasonable amount.
Right.
So on that basis, we're able to do it on contingency from a from a financial sense. And it's good for the client because they don't have to pay us any money up front.
Right.
Yeah.
But they still get the advice and guidance and
Yeah.
Yeah.
Yeah. Yeah. And if everything goes well, we give them a mug and a hat too.
Wow.
ooh,
Yeah.
Excellent.
We have awesome swag. Maybe I'll send you guys some.
Yeah.
Yeah.
Hook us up.
You can wear it on your next podcast, although that would be kind of advertising. You might not pay for it. Yeah. But it's all good. It's all good.
Well, and when we get some access to Justice Swag, we'll hook you up as
Yeah.
one of the original guests.
Yeah.
Yeah.
Exactly.
Well, Mark, do you have any parting words? Is there anything that we haven't asked you that you think our listeners just need to know about employment law before we wrap things up for today's episode?
Well, I guess my only words of advice is that a very smart man said that if you can find a job you enjoy, you never have to work a day in your life. And so what I often tell my clients is, even though they're often sad when they're terminated, or sometimes when they're in a big employment dispute and they don't know what to do, a lot of times it works out for people because it's either a job they shouldn't be in or they don't like, and it gives them a fresh start. They won't know it at the time, but I have had clients call me back after the fact and said, "Hey, Mark, you're actually right. This has been a good thing." I suspect some of my clients also go into poverty and never rebound either, but that's the other side of it as well, joking
Right.
aside. But
Right.
I have had lots of clients call me back and say, "Mark, you know what? As bad as it was, this was actually the best thing that ever happened to me, but it took me a few years to understand it." So
Yeah.
yeah, find a job you enjoy. Yeah, that's what I say. That's my parting word. That's to you, Heather. Find a job you enjoy.
Yeah, Heather.
I'm working on it.
Podcast host.
I am loving this.
Can I go
It's
drink?
fun.
Can I go drink beer now? Is this it?
Yes, this is it, Mark.
Oh, this is exciting.
This has been another episode of Access to Justice. Thanks for listening or watching, however you have spent this last hour with us. If you have any questions you'd like us to address on the podcast, send an email to accesstojustisepodcast@gmail.com, and we'll do our best to get an answer to you on an upcoming episode. Thanks for listening.
Thanks, everyone.
Any information in this video is general information only and is not, nor is it intended to be, legal advice. Watching this video does not create a lawyer-client relationship. You should always seek the advice of a lawyer or other qualified professional for advice regarding your individual situation. While we take care to ensure that the information contained in this video is accurate and up to date, we make no warranties or representations as to the suitability, completeness, or accuracy of the information contained in this video. Any reliance you place on the information is at your own risk. Kahane Law Office, Merrick Law, Heather Malarick Professional Corporation, Evan Clark Professional Corporation, Evan Clark, Heather Malarick, and any guests will not be responsible nor liable in any way for any content, including but not limited to any errors or omissions in the content, or for any loss or damage of any kind occurred as a result of any content communicated in this video, whether by Evan Clark, Heather Malarick, or by a third party. Kim McDonald is a financial advisor with Raymond James Limited. Information provided is not a solicitation, and although obtained from sources considered reliable, is not guaranteed. The view and opinions contained in this media are those of Kim McDonald, not Raymond James Limited. Securities-related products and services are offered through Raymond James Limited, member Canadian Investor Protection Fund. Insurance products and services are offered through Raymond James Financial Planning Limited, which is not a member Canadian Investor Protection Fund. Raymond James advisors are not tax advisors, and we recommend that clients seek independent advice from a professional advisor on tax-related matters. Insurance products and services are offered through Raymond James Financial Planning Limited, RJFP, a subsidiary of Raymond James Limited, which is not a member Canadian Investor Protection Fund. When providing life insurance products, financial advisors are acting as insurance representatives of RJFP.
Darkness of the dales dissipates, declines.